Unit 2B Law of Contracts. Contracts are an important part of commercial law because all commercial law transactions usually begin with an agreement or contract. Business transactions involving sale, purchase, or exchange of services have become an integral part in day-to-day activities. An agreement or a contract is necessary for determining the rights, obligations, and liabilities of parties when they enter into any business transaction. The Indian Contract Act is the law governing contracts in India. Now we will see what is the difference between agreement and contract. Agreement is just a promise between two parties, but when it is enforceable by law, it becomes contract. Contract create legal obligations and liabilities. In other words, we can say all contracts are agreements, but all agreements are not contracts. Now after this, we will see the main principles of contract. The contract starts with the first step, that is offer. A offer B to sell his car, then B accept it. This is the second principle. So offer, acceptance by the B party, and the money 50,000. So for A, car is his consideration, and for B, 50,000 is his consideration. Now we'll see the capacity to contract, that is who can contract. So the basic requirement here that the party should be major, they should not be minor, that is above 18 years, sound mind, and not disqualified by law. They should not be insolvent, foreign sovereign, convict, corporation, or barrister. Now after this, the next very important principle of this contract is free consent. The consent should be free. It should not be due to fear or force. For example, if A threatens to B to sell his house for 50,000 and B accepts the offer, B accepts the offer only due to fear, but later on he can deny it, and this type of contract that would be voidable. Now after this, the contract should not be for unlawful object. It should not be illegal. It should not be for immoral purpose, or it should not be against any public policy or wager. Now after this, when the parties they complete their obligations, then the contract is known as discharge. After this point, I come to this here, discharge of contract. When the legal obligations are completed, then the contract is known as discharge, or in other words, we say that the contract is now terminated. So discharge of contract may be by performance, by agreement, by lapse of time. That is, there should be specific time. According to Limitation Act, the contract to be performed within a specific time, and this is called period of limitation. By operation of law, death of either of the parties, insolvency, merger, unauthorized alteration of terms of agreement, by breach of contract, fail to perform obligation, by impossibility, that is by destruction, death, war, or change in law. After this, now I coming to the last point, that is remedies. If there is an agreement between A or B, A promises to supply 40 cans of oil to B within 3 months, and A fails to supply and he supply only 20 cans. So this is the breach of agreement, and here the B is entitled to get the damages, or you can say remedies. This is also known as doctrine of restitution.